Senator Durbin.
So let me pursue further the question of conflict. A recurring theme in the corruption of the second administration of this president virtually always includes the cryptocurrency industry. They seem to be the ones who have made the path straight for the president to have the biggest year in income in the history of the American presidency. Nothing even gets close to the 1.4, 2 billion, whatever the total number may turn out to be. So should Mr. Blanche have recused himself from the decision to issue the April 2025 memo regarding cryptocurrency enforcement, when in fact he was a holder of cryptocurrency at the time?
Absolutely. Let's remember, Chairman Durbin, that Todd Blanche had promised, in fact, to divest himself of his crypto holdings within 90 days of joining the Department of Justice, something he did not follow through on. The time that he finally divested from his crypto holdings was immediately prior to the hearings last week, at least according to recent reporting. This is the only administration in recent memory that does not have a formal ethics plan. There was a Trump-Vance 2025 transition plan which formalized a number of these ethics matters, though it was a fairly skeletal plan, but it did not survive the transition. And the head of the Office of Government Ethics was fired shortly after Donald Trump began his second term and has not been replaced.
And it's my understanding that his holdings in the crypto were somewhere in the range of 150, 160,000.
To my knowledge, that's correct.
And it's also my understanding that he believes he divested himself by transferring these crypto holdings to his children and grandchild.
Well, that is certainly not in the nature of what you would call anything like a blind trust. You cannot transfer it to members of your family and then say you're not going to be involved, though it is a common practice. But it does not necessarily completely free him of the conflicts that he may have around his own crypto holdings. I believe that an even bigger conflict for him is the crypto wealth, which grows larger every day, of his former client, Donald Trump.
It certainly is. Mr. Carbone, when you were at the U.S. Attorney's Office, what was your understanding of your professional responsibility and ethical duty as a DOJ attorney with regard to investigating industries you had a vested financial interest in?
Well, for most of my career, I was a financial disclosure filer, and you would have to divest. And even if you weren't a supervisor, if you're investigating a particular company, even if it's a publicly traded company or they're a victim in a case, you would either have to divest or get off the case.
There's a slight variation in this theme. In April 2025, then Deputy Attorney General Blanche disbanded the National Cryptocurrency Enforcement Team and shut down ongoing crypto crime investigations when at the time he was holding interest in the industry.
Yeah, as my colleague pointed out, that's not something he should have done.
No, certainly it shouldn't be. May I ask on the question of necessity, which is a legal term which we studied way back when, and I've not had any instance to return to. But in this situation, when it came to signing the infamous memo about criminal tax responsibility, do you think Mr. Blanche should have recused himself from issuing an order granting tax immunity to his former client?
Oh, absolutely.
Absolutely, yes or no?
That's a yes. He should have recused himself. If for no other reason, he had a duty of loyalty to his former client, but I think beyond that, he certainly had involvement, very close involvement. Don't forget, he represented this client in at least 4 different matters. And I don't see how you could enter into a settlement agreement that grants immunity for a former client. It would be adverse to the client. Typically what happens in a tax case is there's a liability, and the IRS tells you that you owe $100 million, and you and okay, we'll settle that. We'll settle it for $80 million. I don't see how he could be involved in something like that.
Mr. Blanche came in my office the day before he testified before this committee and talked about this doctrine of necessity, which, if I recall, applies when there is no other competent decision maker who can take an action. I believe that's the argument he's making. So he believes he and he alone at the Department of Justice could sign that immunity.
Well,
what is your feeling?
I can tell you that there are many competent career people at the Justice Department, certainly in the tax division. There's a Deputy Attorney General. There's AAGs. There are many people. And in fact, I think it's pretty extraordinary that an Attorney General would sign off on any settlement agreement like this. So I don't know how it could possibly be necessary when, as far as I know, Mr. Blanche doesn't have expertise in tax matters. And if we're talking about settling a tax liability, that's something that should be done by the tax division.
You would think
if we're
so.
talking about settling a civil lawsuit, that there are many other competent people in the Justice Department who could have signed off on this.
I may not be around to read it, but there's going to be a history written about this administration, and I think it'll be extraordinary in its corruption. And in these 2 specific instances, the cryptocurrency as well as the immunity, there is just no logical, reasonable explanation for what Blanche did, and now he's seeking a promotion. Ms. Stein, I think the point was made by some of your colleagues and survivors that it still defies any logic that after all of the investigation, after all of the victims, after all the history that occurred, exactly 2 people were prosecuted. One has committed suicide and the other just got upgraded to a posh setting in a federal prison camp. That seems to be a recurring theme I hear from the survivors, incredulous. When you met with Mr. Blanche, did anybody speak about specific individuals who they witnessed as part of this that don't seem to be facing any prosecution?
We didn't speak about specific individuals, but we did ask Mr. Blanche to explain the circumstances around his meeting with Ghislaine Maxwell and her transfer afterwards, and we got no substantive answers. He spoke in circles, he evaded our questions, and so we walked out with no more information than we walked in with.
In my office, his explanation was her life was being threatened, and this is the only way they could protect her. My experience, and I'm not an expert in this field, but I have had some contact with Bureau of Prisons. In those circumstances, they usually transfer the person who's being threatened to a safe setting, often by themselves, so that they are safe, rather than to downgrade their incarceration to the lowest level. It doesn't seem to be logical.
Well, I can tell you, Mr. Durbin, that there are over 1,000 victims of Ghislaine Maxwell and Jeffrey Epstein's crimes that are in fear of our own lives. And we haven't felt any better of that with the disclosure of our personal information by this Department of Justice. This is a sex trafficking case that most prosecutors would be salivating for. The number of victims, the amount of evidence, yet there seems to be no interest in pursuing this.
Mr. Carr, I would just close by saying that I opened one aspect of this hearing the other day by noting the fact that the special counsel that you represented as a spokesman has agreed voluntarily to come before this Judiciary Committee and answer questions under oath. it was 4 months ago or longer, that all the Democratic senators said, if the Republican senators on Judiciary Committee are going to continue to lob these grenades at the former special counsel, they owe it to him to give him a chance to tell his side of the story under oath. And they've refused month after month after month. The conclusion I draw is that they're afraid of what he has to say. I've seen him describe his role in this in earlier investigation, and he seems to know what he's talking about. Would you comment on that?
He has said publicly that he is willing to come and testify publicly. And so I encourage the Senate to take him up on it.
I think we should. Thank you, Mr. Chairman.